All right, we're going live about a half a minute early. All right, wait on a few people to show up. Wait for Reggie Owens over there with Boxing Conversations with Reggie Owens. Claims to be the greatest boxing conversation in America. Here we go. All right, Matt, you gonna jump on? I don't know. Anyways, look, so there was a big Supreme Court decision on the 17th. I don't know who all was watching that or y'all was wondering about the TikTok ban on the 17th. And there's always something. Look, there was a Supreme Court decision that was issued on the 17th. Uh, Moore v. Alliant Credit Union. Um, it it basically canceled all debt in the United States. I've said it before, and I'll say it again. The United States dollar has zero value. It's fiat currency. It is a Federal Reserve note, and a Federal Reserve note is a debt note, and a debt note is a negotiable instrument. A negotiable instrument is an IOU. Under GAAP principles, generally accepted accounting principles, debt is money, and everything is backwards. Um, this decision could have very well canceled debt over globally. All right. Um, so people need to start using the Supreme Court decision every time they do anything. If they're found guilty of a speeding ticket, well, I can't pay that. Moore v. Alliant Credit Union says that I can't. I'm gonna read y'all the entire decision and the conclusion right here. Just know that you heard it first on the Truth with Tex. All right. So, sorry, it was delivered January 14th, not the 17th. I'm sorry. Today, this court renders a decision of profound constitution and societal importance. Get on here, Reggie. What are you doing? There you go.
What's up? What's up, man?
Hey, look, I got my boy Matt Mullins on. He's over in China. Matthew Bergman. He's on here. Everybody's welcome to jump on here, but we can only get 10 people at a time. But I was just starting to read the decision that was delivered on January 14th, but it was let out on the 17th. So Maine, all right, Matthew Bergman from Maine, fantastic. So I'm gonna start reading this. This Supreme Court decision virtually eliminates all debt everywhere. I've said it before, and I'm gonna say it again now. The United States dollar has zero value. It's backed by nothing other than the faith and credit of the American people. All right, the credit of the American people is all their future labor. All right, that was pledged to the Federal Reserve. But look here, I'm just gonna read this. Today, this court, this case is Moore v. Alliant Credit Union. Today, this court renders a decision of profound constitutional and societal importance. At issue is whether the foreclosure proceedings initiated by Alliant Credit Union against Mr. Zachary Moore, based on a mortgage loan derived from fiat currency, violated his constitutional rights under the 5th, 13th, and 14th Amendments. This case also raises broader questions about the legality of a monetary system that facilitates perpetual debt cycles through fiat currency and usury. We was just talking about that in the last podcast. What, 2 days ago, yesterday, whenever it was. Look, fiat is false, fake currency. All right, a debt-based currency. There is no value because it's backed by nothing. Moving on. After careful consideration, we hold that the foreclosure proceedings as applied to Mr. Moore constitute an unconstitutional deprivation of his rights to property and due process under the 5th and 14th Amendments. Further, we find that the systemic exploitation inherent in the fiat currency system and its application to the facts of this case violate the foundational principles of justice enshrined in the Constitution. Got my Constitution. Let's look up what it says right there. Article 1, Section 10, Clause 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender of payment of debts. I've been saying that for a long time. Very few people want to listen. All right, now, moving on. The constitutional context. At the heart of this case lies a mortgage agreement secured by fiat currency, currency that is created without backing by tangible assets, such as gold or silver. Mr. Moore argues that this currency, lacking intrinsic value, fails to constitute valid consideration under contract law, thereby rendering his mortgage void ab initio. He further asserts that the foreclosure proceedings based on such a contract violate his rights to due process, equal protection, and protection from unjust enrichment. The Constitution is clear on matters of monetary integrity and individual rights. Article 1, Section 10 prohibits states from making anything but gold and silver coin a tender in payment of debts. This provision reflects the framers' intent to establish a monetary system grounded in tangible value, ensuring fairness and stability in economic transactions. Moreover, the 5th and 14th Amendments safeguard individuals from governmental deprivation of life, liberty, or property without due process of law. We cannot ignore the systemic exploitation facilitated by the fiat currency system, which imposes undue burdens on individuals like Mr. Moore. The system, compounded by the practice of usury, creates perpetual cycles of debt that are not only mathematically unsustainable, but also morally indefensible. 2. Fiat currency is unconstitutional consideration. The issue of consideration is foundational to the validity of contracts. A valid contract requires mutual exchange of value. However, fiat currency, by its very nature, is created out of nothing and lacks the tangible backing required by Article 1, Section 10. This court has long recognized the principle that invalid consideration undermines the enforceability of a contract in Carpenter v. Logan, 1872. We held that a mortgage is inseparable from the promissory note it secures. If the note is invalid, the mortgage is likewise void. Here, Mr. Moore's mortgage was based on fiat currency, a medium of exchange that contravenes constitutional intent and economic fairness. We conclude that such a contract lacking valid consideration cannot form the basis for lawful foreclosure proceedings. Number 3, violation of the 5th and 14th Amendment. The foreclosure proceedings also implicate Mr. Moore's due process rights. The 5th Amendment prohibits the deprivation of property without due process of law, and the 14th Amendment extends this protection to actions by state governments and their instrumentalities. Foreclosure is a significant deprivation of property that requires strict adherence to procedural and substantive fairness. In this case, the foreclosure was initiated without addressing Mr. Moore's valid challenge to the underlying mortgage. The lack of a meaningful hearing to contest the validity of the contract constitutes a violation of his due process rights. Further, the seizure of Mr. Moore's home under a void contract amounts to an unconstitutional taking of property for private benefit, violating the takings clause of the 5th Amendment. The 13th Amendment and economic exploitation. The 13th Amendment's prohibition of involuntary servitude extends to systems of economic exploitation that coerce individuals into perpetual labor for the benefit of others. Telling you. The fiat currency system, when coupled with usury, forces borrowers into unrelenting cycles of debt repayment, effectively constituting economic servitude. Mr. Moore's plight illustrates the oppressive nature of this system, which prioritizes the enrichment of financial institutions over the rights and dignity of individuals. 5. A call to restore constitutional principles. The decision is not merely about the rights of one man. It is a reckoning with systemic injustices that have persisted for decades. The framers of the Constitution envisioned a monetary system that would safeguard against the exploitation and instability inherent in fiat currency and usury. By ruling in favor of Mr. Moore, this court reaffirms the supremacy of constitutional principles over entrenched financial practices. The momentous importance of this decision cannot be overstated. It restores the rule of law in the realm of economic transactions, reasserts the constitutional mandate for sound money, and champions the rights of individuals against systemic exploitation. This ruling also serves as a reminder to all institutions, public and private, that the Constitution is not a mere relic of the past, but a living charter of justice. Conclusion. For the foregoing reasons, we hold that the foreclosure proceedings against Mr. Moore are unconstitutional and void. We further declare that contracts based on fiat currency lack valid consideration and cannot form the basis for lawful enforcement actions. Finally, we call upon Congress to revisit the monetary and financial systems in light of their constitutional obligations and the principles articulated in this opinion. The judgment of the lower court is reversed. It is so ordered. Every motherfucking contract that fucking is to be repaid in Federal Reserve notes, US dollars, is now fucking void. Anybody who demands to be paid in fucking US dollars, you can't. Because it's money backed by fucking nothing. Silver and gold are the only two things that you could utilize in order to repay a debt. What do you think, Reggie?
I'm still not rock with it, man. This your belief, man. So I mean, the dollar's gonna always be there.
Supreme Court ruling. It's a Supreme Court ruling. You just heard what I said, right?
The Supreme Court. So how you gonna bring gold back to the standard?
What, do what now?
How you gonna go back to the standard of gold? So the fiat currency is what it is.
You kick the Federal Reserve out the fucking country. That's the first step right there. Right there. The Supreme Court just said, fucking, your dollar bill is worthless. It has no fucking value.
But how,
if it has no value, then it can't be.
How do you go about removal of the reserve? Who? That has to be a call from who?
Legislature. So there should be a decision made by the legislature, backed by the executive branch of the government. Since the Supreme Court has already ruled on the constitutionality right there of fucking goddamn fiat currency. And all they got to do is say, okay, you've loaned us all these dollars, but we can't pay you back with dollars because only silver and gold could be paid back. But since you gave us nothing, since you loaned us nothing of value, it can't be paid back by anything with value. Get the fuck out of here.
Yeah, go into what the fiat currency is, because I'm pretty sure there's a reason why that standard has changed to that standard. Fiat
currency. Fiat simply means fake money.
Yeah, but there's still got to be a way to balance it on the books.
Well, sure. The United States fucking prints a fucking gold coin. You know, something on a gold coin that says this is worth fucking $34 trillion and hands it over to them. Said, there you go. That's all they got to do.
Yeah, so it's like, they say in the so fiat is a type of government issue currency that's not backed by precious metal.
No, it's not. It's not government issued. It's fucking. Yeah. It's privately issued from the Federal Reserve System. The Federal Reserve is not federal or fucking constitutional in any way.
It got to be linked to this system. It has to be.
The Federal Reserve is a private for-profit corporation owned by the Little Hats, subservient only to the World Banking Organization and the International Monetary Fund. That's it. The Little Hats own that motherfucker too. All right. So this is what they were fucking voted in by a number of 4 motherfuckers. All right. At midnight on Christmas Eve in fucking 1912. That's it.
Yeah, it says the banking system in the United States. Yeah.
It's not the banking system of the United States. Well, yeah, it is the banking system of the United States, being that the United States is a corporation. The corporate United States.
See, that's what I like to get into, because I know, I'm always opposed to the opposite side on a lot of shit, because I'll be one to understand it and just thinking like nothing was just created out the thin blue air to say fuck gold, fuck silver. There's a reason behind whoever enacted this change, the reason behind it, and discovering the reason behind that. And then when you develop
in 1933.
So I know it's probably
in 1933 there was something called the
Great Depression. But go ahead.
Yeah, so in 1933 there was something created called the Trading with the Enemies Act. Well, that was 1919, but they added a clause in there in 1933 that the gold that people had, because people still had gold coin, gold bullion, gold bars, whatever, that they held in their homes, that they didn't turn into the banks for fucking reserve notes, right? And so in 1933, they added a clause to the Trading with the Enemies Act stating that people could very well take gold, a big ass fucking heavy gold bar, all right, and ship it over to fucking whoever, right, that could potentially be a fucking enemy of the United States and help fund them like that. Bull motherfucking shit. They made it illegal to have anything more than 1 troy ounce of gold. And they gave it to the government. Fucking, it was 6 months later, or no, 3 months later. 3 months later, at that point in time, globally, the president of the United States had the ability to set the price of gold. All right? When everybody gave up their gold, because why would the government lie to them, right? They turned it all in. The government accepted all this gold and took acquisition of it. 3 months later, because there was a 3-month time stamp on that shit. If you didn't turn in all your gold and somebody come and kicked your fucking door in and found you had gold, you was a felon on the fucking federal level. All right? So it was like 3 months and 3 days, fucking the president decided to reset the price of gold. Hiked it up $26 and then sold all that motherfucking shit off. You know, damn good and well, there ain't no fucking gold in that goddamn in Fort Knox, Kentucky. You was there. You seen it, same as I did. Motherfucking clowns marching around with no fucking goddamn magazine in their weapon. What are they guarding? They ain't guarding fucking dog shit. There ain't nothing to guard. That's fucking special duty. Hey, if you've been a fucking good boy, we'll let you march around with a motherfucking rubber duck in your fucking hands that look like a rifle, and you can ride around a goddamn up armored Humvee and fucking and play pretend for fucking 8 hours a day. Just run 3-hour tower. There's 3 shifts. If you was a real good boy, we'll put you on during the day. Pat you on your head. Tell you fucking how great you done. Put a medal, give you a fucking medal, let you win a fucking award. Come on, man.
Let's see. Kenny Porter right hand wrote something.
The economic downturn was due to them fucking what was highly due to them stealing the fucking gold. I know that the Great Depression started in 1932, but it was sure enough fucking exacerbated in 1933 when they stole all the motherfucking gold.
Yeah, but see, I think that makes sense to why they moved away from that gold standard. Like I say, I'm like, I just don't think they'll just pull away the gold and then you create the standard. I don't think it changes anything, being that gold and precious metals. Let me just say this: they're limited resources. So with the limitations and resources, certain individuals can gain, unsurmountable amounts of control and wealth. So you can virtually have control of a country as well if you're basing it off of that.
Well, just like fucking
you also, but then the other side, you limit a person's level of wealth until more of this stuff is dug from out of the earth. So I think that the fiat currency allows the expansion of wealth to span to the population and shit. So I'm thinking that's the reason behind this type of system.
But it's not wealth, all right? So $1, one Federal Reserve note equals $1 worth of fucking debt, and that's it, and nothing else. So if the Federal Reserve was to accelerate the debt and call in their fucking tick, call in their fucking note, the motherfucker who's got $1 million in his bank account is holding $1 million worth of debt. All of that belongs back to the Federal Reserve System. Render unto Caesar what is Caesar's, and render unto the Lord what is the Lord's. Fucking, so they take all that shit back.
So what do you say for guys like Elon Musk and Jeff Bezos accumulating all this wealth? I don't think they don't seem to have an issue with it.
It's a good thing they fucking paying themselves in fucking stock, because once that shit fucking blows up in the face of the government, because it is completely fucking unsustainable. When it blows up in the face of the government and people start to wake up and realize what fucking full faith and credit means, then they've still got the stock. The stock is still there. Does the stock plummet? Oh, it fucking plummets in US dollars. US dollars ain't worth shit anyways. They ain't worth the fucking paper they're printed on. Right?
So with that said, what currency you says is worth something? Because I don't know if any nation goes by a standard of metals. I think they all have
two of them. China,
name them.
China and Russia. China and Russia. I know that for sure. And also every fucking country that we went to fucking go blow up. Iran, the one they saying is a big fucking enemy, they own the fucking gold standard. They ain't got no fucking centralized bank. I'm telling you, every war is a fucking banker's war. Iraq, the Iraqi dinar, it was like one Iraqi dinar to fucking 56 US dollars. The Iraqi dinar was fixing to be picked up as the goddamn reserve currency of the world. That's why we had to go over there and blow their fucking ass up for the fucking little hats. Them little hats, boy, fucking, I'm telling you, them little hats is fucking clever.
Yeah, but see, I think currency is based off of the production of the innovation and production of your country. What can you offer to the global world, to the world on a global scale? What you rank? I think that's what currency, in my thoughts, is based off of. Iraq has, like you're bringing up Iraq. What do they have to bring to the global economy? Nothing but fuel. They don't produce anything outside of that. That's no different than Saudi Arabia.
Just 1 second. I'm putting the link back up there. Andrew, hey, jump on here if you want to. Yeah, the only thing that the United States has pledged is all future labor. All future labor is pledged to the Federal Reserve and all their organizations. All future labor. What does that mean? When you tell me what that means to you.
That's going to be our kids. That's what anything in the future. It's going to be kids, grandkids.
Your future labor. What is when some motherfucker in a goddamn suit fucking pledges your future labor?
Oh, you mean until my death? So you're talking about down the line? So from current down to 20 years or some shit.
If I was to say, fucking, you know what? In order to facilitate this phony fucking money, I'm gonna pledge all the fucking Reggie's future labor to you. What does that mean to you? What is that?
Yeah, no, it's until my retirement, or until my death. So
no, it's fucking slavery. That's what the fuck it is.
What, they still got to pay me.
Pay you in fucking money that has no value.
What you mean no value? I can go with that's what I don't get. A lot of y'all be saying this about the dollar. I don't rock with it. So say I work.
All right.
Let me say this. The money has value. Now the strength of the dollar, yes, it changes. The dollar, as any currency, a currency can strengthen, it can weaken. Now, if I need to go buy something, I still got to use some sort of currency. Like even if I was, and this other thing where I hear with the precious metals, if I go out and buy silver, I go buy this, how do I trade this shit in to purchase anything? I can't walk in the store with a gold bar. Somebody has to buy that shit off of me, right?
I'm gonna bring up the affidavit of Walker Todd. Walker Todd was an attorney for the Federal Reserve banking system. I'm gonna find it real quick, and he gave an affidavit to the court because they called him where is this shit?
What year is this from?
Damn it. Let me see if I can find this shit. Hold on.
All right. You know how to you pulling it up on the screen?
Yeah, I've got it in my documents.
Okay.
There it is. And we'll read the whole motherfucking thing because he tells you that that money is backed by nothing, and he tells you the definitions. He tells you what the difference is between money of account and money of exchange. All right, I'm gonna bring this up. All right. Now comes the affiant, Walker F. Todd, a citizen of the United States and the state of Ohio over the age of 21 years, declares as follows under penalty of perjury. That I am familiar with the promissory note and disbursement request and authorization dated November 23rd, 1999, together sometimes referred to in other documents filed by defendants in this case as the alleged agreement between defendants and plaintiffs, but called the note in this affidavit. If called as a witness, I would testify as stated herein. I make this affidavit based on my own personal knowledge of the legal, economic, and historical principles stated herein, except that I have relied entirely on documents provided to me, including the note regarding certain facts at issue in this case, of which I previously had no direct or personal knowledge. I am making this affidavit based on my experience and expertise as an attorney, economist, economist, and research writer and teacher. I am competent to make the following statements. Professional background and qualifications. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers' acceptances, securities, and other financial instruments in connection with my work for the Reserve Bank's discount windows and parts of the open market trading desk function in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal history of central banking and the pledging of notes, bonds, and other financial instruments at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. I also have read extensively treatises on the legal and financial history of money and banking, and have published several articles covering all the subjects just mentioned. I have served as an expert witness in several trials involving banking practices and monetary instruments. A summary biographical sketch and resume, including further details of my work experience, readings, publication, education, will be tendered to defendants and may be made available to the court to plaintiff's counsel upon request. Banks are required to adhere to generally accepted accounting principles, or GAAP. GAAP follows an accounting convention that lies at the heart of the double entry bookkeeping system called the matching principle. This principle works as follows. When a bank accepts bullion, coin, currency, checks, drafts, promissory notes, or any other similar instruments, hereinafter instruments, from customers and deposits or records the instruments as assets, it must record offsetting liabilities that match the assets that it accepted from customers. The liabilities represent the amounts that the bank owes the customers. Funds accepted from customers in a fractional reserve banking system like the United States banking system, most of the funds advanced to borrowers, assets of the bank, are created by the banks themselves and are not merely transferred from one set of depositors to another set of borrowers. Relevance of subtle distinctions about types of money. From my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money, unfortunately, has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money: money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, e.g., gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. The sum of these transactions is the sum of credit extensions in the economy. With the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Against this background, I conclude that the note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayment or settlement in money of account. That is, money of exchange would be welcome, but is not required to repay or settle the note. The factual basis of this conclusion is the reference in the disbursement request and authorization to repayment of $95,905.16 to Michigan National Bank from the proceeds of the note. That was an exchange of the credit of Bank One, plaintiff, for credit apparently and previously extended to defendants by Michigan National Bank. Also, there is no reason to believe that plaintiff would refuse the substitution of the credit of another bank or banker as complete payment of the defendant's repayment obligation under the note. This is a case about exchanges of money of account, credit, not about exchanges of money of exchange, lawful money, or even legal tender. Ironically, the note explicitly refers to payment in lawful money of the United States of America. See promise to pay clause. Traditionally and legally, Congress defines the phrase lawful money for the United States. Lawful money was the form of money of exchange that the federal government or any state could be required by statute to receive in payment of taxes or other debts. Traditionally, as defined by Congress, lawful money only included gold, silver, and currency notes redeemable for gold or silver on demand. In a banking law context, lawful money was only those forms of money of exchange, the forms just mentioned, plus U.S. bonds and notes redeemable for gold, that constituted the reserves of a national bank prior to 1913. Date of creation of the Federal Reserve Bank. See lawful money, Webster's New International Dictionary, 2nd edition. In light of these facts, I conclude that plaintiff and defendants exchanged reciprocal credits involving money of account and not money of exchange. No lawful money was or probably ever would be dispersed by either side in the covered transactions. This conclusion also is consistent with the bookkeeping entries that underlie the loan account in dispute in the present case. Moreover, it is puzzling why the plaintiff would retain the archaic language lawful money of the United States of America in its otherwise modern-seeming note. It is possible that this language is merely a legacy from the pre-1933 era. Modern credit agreements might include repayment language such as the repayment obligation under this agreement shall continue until payment is received in fully and finally collected funds, which avoids the entire question of in what form of money or credit is the repayment obligation due. 6, legal tender, a related concept, but one that is economically inferior to lawful money because it allows a payment in instruments that cannot be redeemed for gold or silver on demand, has been the form of money of exchange commonly used in the United States since 1933, when domestic private gold transactions were suspended until 1974. Basically, legal tender is whatever the government says that it is. The most common form of legal tender today is Federal Reserve notes, which by law cannot be redeemed for gold since 1934 or since 1964 for silver. See 31 U.S.C. Section 5103, 5118B, and 5119A. Note, I question the statement that the Federal Reserve notes cannot be redeemed for silver since 1964. It was Johnson who declared on 15 March 1967 that after 15 June 1967, the Federal Reserve notes would not be exchanged for silver, and the practice did stop on 15 June. So you remember who was going to put us back on the silver standard, right? You remember who took over for him after he was murdered, right? Anyways, moving forward.
Legal you said under wait. You said you meant after Kennedy.
Yeah, because
you said Hoover. You threw me off because you said Hoover. No, you threw me off. You said Hoover.
Oh no. Who was going to put us back on the silver standard, and who took over for him after he was murdered?
Right. Anyway, I got you.
Number 7. Legal tender under the Uniform Commercial Code, UCC, Section 1201-24, official comment, is a concept that sometimes surfaces in cases of this nature. The referred official comment notes that the definition of money is not limited to legal tender under the UCC. Money is defined in Section 1201 as a medium of exchange authorized or adopted by a domestic or foreign government and includes a monetary unit of account established by an intergovernmental organization or by agreement between 2 or more nations. The relevant official comment states that the test adopted is that a sanction of government, whether by authorization before issue or adoption afterward, which recognizes the circulating medium as a part of the official currency of that government, the narrow view that money is limited to legal tender is rejected. Thus, I conclude that the UCC tends to validate the classical theoretical view of money. How banks began to lend their own credit instead of real money. In my opinion, the best sources of information on the origins use of credit as money are in Alfred Marshall, Money, Credit, and Commerce, A Financial History of Western Europe. A synthesis of these sources. Also, Modern Money Mechanics. All right, that's put out by the Federal Reserve of Chicago. Modern Money Mechanics. Hey, if it's chapter 3, and Modern Money Mechanics is going to tell you that fucking Federal Reserve notes are worth fucking nothing. Moving on. A synthesis of these sources as applied to the facts of the present case is as follows. Commercial banks and discount house, private bankers, became established in parts of Europe, especially Great Britain and North America. By the mid-19th century, they commonly made loans to borrowers by extending their own credit to the borrowers or, at the borrower's direction, to third parties. The typical form of such extensions of credit was drafts or bills of exchange drawn upon themselves, claims on the credit of the drawees, instead of disbursements of bullion. Bullion coin or other forms of money in transactions with third parties. These drafts and bills came to serve most of the ordinary functions of money. The third parties had to determine for themselves whether such credit money had value and, if so, how much. The Federal Reserve Act of 1913 was drafted with the model of the commercial economy in mind and provided at least 2 mechanisms: the discount window and the open market trading desk, by which certain types of bankers' credits could be exchanged for Federal Reserve credits, which in turn could be withdrawn in lawful money. Credit at the Federal Reserve eventually became the principal form of monetary reserves of the commercial banking system, especially after the suspension of domestic transactions in gold in 1933. Thus, credit money is not alien to the current official monetary system. It is just rarely used as a device for the creation of Federal Reserve credit that, in turn, in the form of either Federal Reserve notes or banks deposits at Federal Reserve banks, functions as money in the current monetary system. In fact, a means by which the Federal Reserve expands the money supply, loosely defined, is to set banks' reserve requirements, currently usually 10% of demand liabilities, at levels that would encourage banks to extend new credit to borrowers on their own books that third parties would have to present to the same banks for redemption, thus leading to an expansion of bank-created credit money. All right, so what they're talking about there, 10%, is they only have to have 10% of the money on hand, 10% of the Federal Reserve notes on hand, in contrast to the 90% that they have loaned out by virtue of a computer fucking typing something into a computer and saying fucking, okay, now you got $100,000. So if they loaned out, just say it was a bank that loaned out $90,000, or I'm sorry, $100,000, they only have to have $1,000 in reserves. Moving on. In fact, let's see, leading to an expansion of bank-created credit money. In the modern economy, many non-bank providers of credit also extend book credit to their customers without previously setting aside an equivalent amount of monetary reserves. That's what they're doing in the fucking courts. All right, credit card line of credit access checks issued by non-banks are a good example of this type of credit, which also causes an expansion of the aggregate quantity of credit money. The discussion of money taken from Federal Reserve and other modern sources in paragraphs 11 is consistent with the account of origins of the use of bank credit as money in this paragraph. Plaintiff apparently asserts that the defendant signed a promise to pay, such as a note or credit application, collectively the note, in exchange for the plaintiff's advance of funds, credit, or some type of money to or on behalf of defendant. However, the bookkeeping entries required by application of GAAP and Federal Reserve's own writings should trigger close scrutiny of plaintiff's apparent assertions that it lent its funds, credit, or money to or on behalf of defendants, thereby causing them to owe the plaintiff $400,000. Banks cannot loan their credit. They have no fucking credit. They're loaning you your own motherfucking credit. All right? According to the bookkeeping entries shown or otherwise described to me in application of GAAP, the defendants allegedly were to tender some form of money, lawful money of the United States of America is the type of money explicitly called for in the note, securities or other capital equivalent to money, funds, credit, or something else of value in exchange. Money of exchange loosely defined, collectively referred to herein as money to repay what the plaintiff claims was the money lent to the defendants. It is not an unreasonable argument to state that plaintiff apparently changed the economic substance of the transaction form from that contemplated in the credit application form, agreement, notes, or other similar instruments that the defendants executed, thereby changing the costs and the risks to the defendants. At most, the plaintiff extended its own credit, money of account, but the defendants were required to repay in money, money of exchange, and lawful money at that, which creates at least the inference of inequality and of obligations on two sides of the transaction. To understand what occurred between plaintiff and defendants concerning the alleged loan of money, or more accurately, credit, it is helpful to review a modern Federal Reserve description of a bank's lending process. See David H. Friedman, Money and Banking, 4th edition, 1984. The commercial bank lending process is similar to that of a thrift, and that the receipt of cash from depositors increases both its assets and its deposit liabilities, which enables it to make additional loans and investments. When a commercial bank makes a business loan, it accepts as an asset the borrower's debt obligation, the promise to repay, and creates a liability on its books in the form of a demand deposit in the amount of the loan. Therefore, the bank's original bookkeeping entry should show an increase in the amount of the asset credited on the asset side of the books and corresponding increase equal to the value of the asset on the liability side of the books. This would show that the bank received the customer's signed promise to repay as an asset, thus monetizing the customer's signature and creating on its books a liability in the form of a demand deposit or other demand liability of the bank. I'm telling you, I've told y'all, I've said it. Your signature is money. Your signature is what creates the fucking money. The bank then usually would hold this demand deposit in a transaction account on behalf of the customer, instead of the bank lending its money or other assets to the customer, as the customer reasonably might believe from the face of the note. The bank created funds for the customer's transaction account without the customer's permission, authorization, or knowledge, and delivered the credit on its own books, representing those funds to the customer, meanwhile alleging that the bank lent the customer money. If plaintiff's response to this line of argument is to the effect that it acknowledges that it lent credit or issued credit instead of money, one might refer to Thomas P. Fitch, Barron's Business Guide, Dictionary of Banking Terms, credit banking, bookkeeping entry representing a deposit of funds into an account. But plaintiff's loan agreement apparently avoids claiming that the bank actually lent the defendants money. They apparently state in the agreement that the defendants are obligated to repay plaintiff principal and interest for the valuable consideration the bank gave the customer. The loan agreement and note apparently still delete any reference to the bank's receipt of actual cash value from the defendants and exchange of that receipt for actual cash value that the plaintiff banker returned. According to the Federal Reserve Bank of New York, money is anything that has value, that banks and people accept as money. Money does not have to be issued by the government. In other words, fucking if I wrote fucking worth $1 or worth, you know, valued at $100 and then sign the motherfucker on a goddamn shit ticket and fucking turn the some bitch over. If somebody accepted that fucking on my credit, that's worth $100 fucking dollars.
It'll never happen like that though, man.
Well, fucking maybe if I don't wipe my ass on it first, fucking I'll just have to start buying rougher paper. That way I can start issuing my own money. For example, David H. Friedman, I bet you thought, Federal Reserve Bank of New York, 4th edition, 1984, apparently already introduced in this case, explains that banks create new money by depositing IOUs, promissory notes, offset by bank liabilities called checking account balances. Page 5 says, money doesn't have to be intrinsically valuable, be issued by government, or be in any special form. That's why nobody can fucking demand repayment at any specie of currency. The publication, Anne Marie L. Gonzi, Modern Money Mechanics. Here we go. Federal Reserve Bank of Chicago, revised edition, June 1992, apparently already introduced into this case. Contains standard bookkeeping entries demonstrating that money ordinarily is recorded as a bank asset, while bank liability is evidence of money that a bank owes. The bookkeeping entries tend to prove that banks accept cash, checks, drafts, and promissory notes, credit agreements, assets as money deposited to create credit or checkbook money that are bank liabilities, which show that, absent any right of set-off, banks owe money to persons who deposit money. Cash, money of exchange, is money, and credit or promissory notes, money of account, become money when banks deposit promissory notes with the intent of treating them like deposits of cash. The plaintiff acts in the capacity of a lending or banking institution, and the newly issued credit or money is similar or equivalent to a promissory note, which may be treated as a deposit of money. When received by the lending bank, Federal Reserve Bank of Dallas publication Money and Banking explains that when a bank grant loans, they create new money. They create new money based upon what? Your fucking signature. The new money is created because a new loan becomes a deposit, just like a paycheck does. Modern Money Mechanics, page 6 says what they do when they make loans is to accept promissory notes, right? That's your signature, in exchange for credit to the borrowers, transaction accounts. The next sentence on the same page explains that the bank assets and liabilities increase by the amount of the loan. Commentary and summary of argument. Plaintiff apparently accepted the defendant's note and credit application, money of account, in exchange for its own credit. Accepted the defendant's note and credit application in exchange for its own credit. All right? And deposited that credit into an account with the defendant's names on the account, as well as apparently issuing its own credit for $95,905.16 to Michigan National Bank for the account of the defendants. One reasonably might argue that the plaintiff recorded the note or credit application as a loan, money of account, from the defendants to the plaintiff, and the plaintiff then became the borrower of an equivalent amount of money of account from the defendants. Right? So the plaintiff became the borrower of the fucking money, right? That means the bank became the borrower of the money from the defendants, right? Who issued the new money by virtue of their signature. The plaintiff, in fact, never lent any of its own pre-existing money, credit, or assets as consideration to purchase the note or credit agreement from the defendants. I add that when the bank does the foregoing, then in that event, there is an utter failure of consideration for the loan contract. When the plaintiff deposited the defendant's $400,000 of newly issued credit into an account, the plaintiff created from $360,000 to $400,000 of new money. The nominal principal amount, less up to 10% or $40,000 of reserves for the Federal Reserve would require against a demand deposit of this size. The plaintiff received $400,000 of credit or money of account from the defendants as an asset. GAAP ordinarily would require that the plaintiff record a liability account, crediting the defendant's deposit account. Reggie, do I need to go on, or do you understand that fucking money has no intrinsic value and that your signature is what creates new money from the Federal Reserve that is fucking backed by nothing but the faith and credit of the people of the American people, and the fucking credit of the American people is nothing more than future labor?
No, I mean you rock with this, man, but so what's the argument And how do you go about resolving this? What do you think is the way to run the monetary system? And then I got to follow up to that.
It's got to be gold or silver, or a note that is redeemable in gold or silver.
But what if you don't have enough of this resource? Because this is the other thing, that gold doesn't stabilize the value of the dollar if it's backed by gold. The price of gold, and then what sets the price of gold? The scarcity, right? The limitations of gold. And so now, do you put into where it's in the hands of particular people like Elon Musk, the Trumps? Those are the types that buy gold. People at certain classifications in economics, you have no value. You remain a slave, regardless of how you feel with both systems. You still remain a slave in it. How are you able to purchase gold if the value goes up because only a certain percentage of this 1% class retains all this precious metal? How do you obtain it if the prices are set extraordinarily high?
So I didn't get to the end because it was kind of lengthy, and I know it was really dry, and I think people were probably falling asleep when I was reading the affidavit of Jonathan May. But he was offering a reasonable or viable alternative to the Federal Reserve.
No, the link is in the chat because some people had some rebuttal. Go ahead.
Okay, so I'll put it up in there again. All right, so Jonathan May, what he was offering was all of the gold that had been found on the property that he owned in Colorado, along with the value of the land itself, which is only going to go up over time, right? The value of gold is going to go up. The value of silver is going to go up. He excluded any minerals or anything, but that's because they didn't know if there was oil there or any other trace mineral or anything. He knew about gold and silver deposits, right? So the value of the land itself goes up. I think it was 900,000 acres was what he had. And the approximate amount of gold and silver deposits within that 900,000 acres. All right, so he was taking that, and also the value of his trust, and he was going to offer monetary notes against that, but never to exceed 25%.
Oh, you got somebody. Pittsburgh T is in the background too.
Oh, okay. Let me get him on there. Hey, I'm sorry about that. T, you on?
What's happening, fellas, man? I see y'all tapping in on that financial stuff. I kind of disagree with you. I get where you're going with it, though. The market, a lot of that stuff kind of changed, though, because they got a bank repo program right now where they swap out money. And the government been running that since the great collapse under Obama, where they throwing trillions of dollars back up the system. They've been running that for a minute. And the Federal Reserve, what they've been doing, they've been loaning that money out that the banks have for little or no money. I don't know what the rate is right now, but it's at the window. It's called the window money. The window is what the banks borrow at.
Yeah, the discount window.
Right, it's called the window. And that number's always been, and that's been running for a while. They've been propping that stuff up for a minute. So a lot of the stuff between that bank repo program, which they throw trillions of dollars towards the banks, and that's a crazy number if you ever look it up. And how that whole thing works, it's real dry if you try to look it up. But that system is kind of updated compared to that stuff.
It's all money of account. Like, so I'm gonna break something down for you. So there is and the government's involved in this bullshit too. There's a corporation called Ginnie Mae, GNMA, the Government National Mortgage Association. All right, and I've been on their website, and they sit around and they talk about fucking on their website, and it's all publicly accessible. You go look it up yourself. I'm not gonna steer your ass wrong. Go to the GNMA website and start just going through it and going through all the tabs. and they sit there and they talk about how they are actually involved in usury, but they're gonna claim plausible deniability by moving certain things around and using other independent corporations to launder fucking money through. When I say money, it's all fucking money of account, because, and they talk about fucking bundling promissory notes and deeds of trust in bundles of 25 to sell them off as fucking mortgage-backed securities. It's all fucking usury, and they're taking the fucking interest and they're paying themselves with it, and they're paying out their flunkies, the other independent corporations that they're using as shell corporations. It's all on the website. And then this is what else it says on there, that Ginnie Mae, it should never be mentioned as Government National Mortgage Association. Anybody that fucking that uses Government National Mortgage Association instead of Ginnie Mae is at liability for a federal fucking felony. 15 years in the federal penitentiary. Come get me, motherfuckers. Shit. I'm gonna tell everybody. I'm gonna let everybody know. Everybody ought to go fucking look at that shit. Just spend an hour looking at that shit. That shit'll fucking curl your hair.
But
that's the whole system. That's the whole. Go ahead, Reg. Sorry, go ahead.
Yeah, I was gonna say. So, do you really think that the gold standard system is a more efficient system than what the current banking system has in play?
It doesn't matter what's more efficient. It's about what's constitutional.
Everything is about efficiency, bro. The Constitution is so it's like so old written. It's written way long ago. You don't have the economy, the scales of the economy that you have currently. In today's system, do you think the gold standard is a more efficient system than today's system?
So, well, yeah, as a matter of fact, because it's actually backed by an asset. It's not backed by fucking more debt or what they could call commercial paper.
Well, the dollar's backed up by IRS on stuff. The dollar's backed up by IRS, by the money they collect every year.
You mean taxes and all that stuff?
Taxes, right. Whatever taxes they collect, that's what they're backing up.
That's why in the speech, tariffs is a big talking point.
Yeah, all of that.
What they're saying in that decision that I read y'all from 2014 that was released on on the 14th. It was made on the 14th and released on the 17th. And from what the affidavit of Walker Todd just said is it's not propped up by what? Fucking the Federal Reserve is issuing fucking Federal Reserve notes backed by nothing other than fucking the Federal Reserve notes is an IOU. It's a promise to pay attention. And so we're gonna take fucking Federal Reserve notes and fucking pay taxes with them. You can't. Fucking it's like saying, okay, well, fucking y'all issued the Federal Reserve issued into the economy a fucking worthless piece of paper that I was given as a wage but for my labor. So I'm gonna take this worthless piece of paper and pay off a fucking debt with it. You can't. Fucking it's stated right there in the decision that was released three days ago. It's also backed up by the affidavit of Walker Todd. If y'all need somebody who's official, fucking this right there, who is a legal counsel for the Federal Reserve for 20 fucking years.
Yeah, but the economy to change, bro. Like, we're not going back to no gold standard. Like, everything moving towards digital. No country really has their money backed up by gold. None of the major players. They're all running on credit. That's the game. Anybody that tries to force that, we seen what happened with Gaddafi when he tried that. When he tried to run the gold, put the gold standard. What they did to Gaddafi? Yep. No, they not even trying to play that game. They ain't even trying to do that.
Because the World Banking Organization and the fucking International Monetary Fund, along with the Federal Reserve, the fucking Bank of London, fucking et cetera, all the centralized banks are fucking issuing debt currency. And when they call in their fucking tick, when they accelerate the debt and say, y'all got to fucking pay now, what's it going to be paid with? What is backing that? That's what I'm saying.
Well, you know the World Bank is right there in New York City, though. The World Bank is in New York City. Central Bank is
the value
in New York
of
City.
the value of the
What
tender is
control all of
what
that.
backs the debt. So that's how you
Yeah.
pay it. You earn the tender, you pay
They
off.
control all of that. But they don't have to have it because they control everything, is what I'm saying. Like, I get what you're saying, Tex. What I'm telling you is they control everything. So yeah, if they didn't control everything, that would be correct. But if anytime somebody buys oil, they buy wheat, they buy grain, all of that stuff is done with the US dollar, country to country. Don't matter who it is.
But I think when you roll back in time and you look at what caused the panic and them shifting from that, you look at the Great Depression and other things like that, that really caused, whatever administration pushed for that. That's the reason why you come into this system. And probably world bankers have also developed the system, being that the gold standard started becoming an inefficient standard. It couldn't work.
No, but we the world bankers, Reg. Reg, we the world bankers. The World Bank is right there in New York.
Yeah, but we're not a what do you call it, where you just do everything in house. We're not a nationalized system like that.
Bro, listen, the World Bank is right there in New York City. Everything that they do is run out of either New York, Washington, D.C., and they're calling these things international when they're not. America runs them and they give them another title. The Federal Reserve in America runs all the monetary policy off the whole world. They all take cues from America, even if Britain got their own.
So the World Bank is it. Yes, it's there in Washington, D.C., but that is a branch of the World Banking Organization. The other one is the Bank of London, and there's another one I don't remember. I don't remember where it's at. I don't.
It's probably in London too.
There's three banks and or three branches of it, and they are all under the one International Monetary Fund. Right, which is basically a trust organization that owns the trust, known as the World Banking Organization, which then the World Bank Organization owns a trust known as the Federal Reserve, right, or the Central Bank of Germany, or the Central Bank of Luxembourg, or whatever, right? All those centralized banks, and those are all trusts, okay? And all of those central banks have been given authority to print money on behalf of the country, but it's not really on behalf of the country. The countries take the loans from the independent fucking organization known as whatever centralized bank or Federal Reserve, right? And that's why you've got the national debt created. It's backed by nothing other than the future labor of the American people. Now, what happens? What I'm saying is, what happens if they accelerate the debt and they call in the fucking note tomorrow? What happens? We all become slaves. All of our future labor is pledged to the bank. So we go to work and live in fucking squalor while they fucking goddamn get paid back. That's what I'm fucking saying.
But who gonna call it no then?
The Federal Reserve Bank. They can call it at any given time. Which one creates, one controls. That's a maximum law. They're the one that fucking created the Federal Reserve note. They're the one that loaned it out.
But the other thing is the other thing about this change that you talk about, you don't hear none of the wealthy complain about that shit. None of them.
Well, of course they don't, because they're benefiting from the system. But what I'm saying is, if the Federal Reserve was to call in their fucking note, you better believe they'd be fucking complaining about it. Everything's fucking great. Everything's great until it ain't, It's like, oh, well, that happened to them people over there, so I shouldn't be worried about it. But you better be worried about it, because if it happens to somebody else, it's going to happen to you too in time. I didn't understand that for a long fucking time, but I do now.
But they can't, though, Tex. So if they do that, then, look, the banks run off our credit. They make plenty of money off of those credit cards and those car loans and those house loans. The best product they got is that house loan. If they start calling on them notes, they ain't gonna make no money. So they're gonna destroy their own customer.
No, so a mortgage loan, all right? It's a mortgage-backed security, right? So if they call in the fucking note, if they accelerate the debt and they call in the note and you can't fucking pay it in full, then they fucking take your shit. Then they fucking repossess your shit.
They can't do nothing with them properties though, Tex. We seen that when the collapse happened under Bush. Those properties are useless to them. They don't want them properties. Banks don't want properties. They're not in the business of taking your property and keeping it. That does them no good. To notice what they want
you're right.
alone.
You're right. That's why it's sold the very next Wednesday on the fucking courthouse steps under auction. Because they don't want it. You're right. They want the fucking interest. That's what they fucking want. Is the interest paid back.
3x. Yes, 3x. Usually 3 to 4x on a 30-year. That's usually what you're paying back. That's what they want. If you pay it on time, it's 3x. 3 times what you paid for it.
Exactly.
They don't want.
So
they're not going to call it. There's no advantage.
But what that does, I mean, it's created out of thin air, though. Fucking the interest is paid. That's 4 times the money. So they've taken that fucking note, right? That says, say they give you a loan for $100,000 house. That's your $100,000 worth of credit, right? It's already paid. Then you start paying them back with interest, and so now they're able to take that $100,000. They keep $10,000. They have $10,000 on hand. They loan you the $100,000, or they don't really loan you anything because fucking it's all credit. All right. So they're not trading any money of account or exchange. All it is fucking numbers on a computer screen now. Right. So there's nothing tangible. All right. Backed by fucking nothing. Backed by nothing, but except for your signature with your promise to pay. And then they take that fucking $90,000 and they keep 10,000 of that, 9,000, right? And then they loan out $81,000 on top of it. And then out of the 81,000, they keep 10% of that back. And then they loan out the other 90% of that. And then when your interest payments come in, all right, fucking they're creating the money they're creating that amount of money that you have paid back in on top of it all to sit. And that's what's creating the national debt. It's completely unsustainable.
But if they don't have that, Tex, look, this is the problem with that. If they don't have that, nobody can afford to buy a house. That's the problem. They need those loans because nobody's got $300, $400, $500, $1 million to pay for a house. Those products is the way that they have the system set up. I'm not saying it's right. That's just the way that they do stuff because they've made these houses. It's always been unattainable. It's never been where a regular person can afford it.
I understand what they've done, but by virtue of that and by virtue of the courts fucking creating unauthorized fucking bonds, every time they create an unauthorized bond and they sell it on the fucking open market, that much money is created and sent to the fucking court and placed in the CAFR account or in the fucking judge's slush fund account, the fucking 801k, which is an offshore account. All right. Fucking. And so there's this constant creation of money because we don't understand GAAP principles, because we don't fucking know what the fuck they're doing, because we think that a dollar is worth a dollar and does not represent $1 worth of debt. If we understood this fucking shit, all right, and it's all out there for us to fucking read, I'm sharing it with y'all. I'm telling you where to find it, then you would have an understanding of it. And trust me, it took me 6 months to understand that a dollar represented a dollar's worth of debt and not a dollar's worth of wealth and not a dollar's worth of value. I knew it wasn't backed by gold. I knew that, but I still couldn't understand how if I pulled out this motherfucking dollar right here, how I didn't really have a dollar, but I had a dollar's worth of debt. I was holding a debt note. It took me 6 months of reading and rereading and fucking goddamn just immersing myself into shit to understand it. And since more money is created out of thin air all the time based upon the fucking debt that's already been that's been loaned out there by virtue of our credit, by virtue of our signatures, that's what's completely fucking unsustainable. It's backed by fucking nothing. They're not reserving anything other than 10% of it. Only 5% of the debt instruments or the fucking money that's money of exchange that's out there floating around, only 5% is cash money. Anybody can fucking hold on.
Yeah, it depends on the type of bank too, because it could be less than 10. Because some of these they're classified as investment banks. Some of them are classified as a hedge funds. Depends on how they classify themselves, which is a whole nother game that they got going on.
Right. So you've got banks and you've got banking institutions, right? And banking institutions are the ones that do business as banks, but they're not banks because they can't accept deposits. So it might be insurance scheme. It might be the fucking courts. And just so you know, fucking the courts, the judge is the motherfucking is the administrative accountant. All right, because the judge sits on a bench, and in Latin, fucking bank means bench. I mean, but if you look at the legal definitions of words, if you look up the definition of post office, all right, post office, see bank, see court. If you look up the definition of court, see bank, see post office. Look up the definition of bank, see post office, see court. A bank is a post office, is a court. All right. That's why Benjamin Franklin didn't want to be president. He wanted to be postmaster. Because the guy over the post office runs the whole thing. The UPU out of fucking Switzerland, the Universal Postal Union we was talking about the other day. That's why they're always a fucking neutral country in every fucking war. Anyways, I'm getting off topic a little bit.
But you're going way too far back in times. Like their time is nothing compared to what times are like now.
Yeah, because we don't, because everything runs off credit. Everything is digital. We moving away from that.
And for the fact you had, and back then you really had slaves in society back then.
Yeah,
like things are way, way different. The banking system, the productions, the inventions are different.
So everything has value. Like people have value, land have value, cattle have value. Like a lot of things have value. They're physical things.
And commodities. That's what I'm saying. So fucking a commodity-based monetary system, because or backed monetary system, a commodity-backed monetary system is backed by something fucking tangible, something that exists in reality, not the future labor, right? Because that's all that credit is. Credit is debt and future labor.
You look at the transactions back then, like the economies are slow. You had agricultural-based economy. And nothing really else. You didn't have
right.
industrial revolutions like that. Now we live in an economy where we're producing cars, we're producing computers. Like a gold standard system is too inefficient, bro. It'll never work. You'll shut down a system trying to operate off of something like that.
Okay, so let me ask you, what would you back?
You'll have to have an IOU system dealing with gold and shit. The banks
But you can't really do that, though, Reg. You can't do any of that, though, because people wouldn't be able to live.
Yeah, and that's what I'm saying. That's why I'm saying the gold standard wouldn't work in today's times.
Yeah, because if you did that, how would people? Okay, so the guy who makes $60,000 a year, that's all he making. He getting checks. How is he going to get his money? How are you going to afford cars and all this stuff if he can't get a car loan, if he can't use credit cards? Because banks are no longer going to loan that stuff out now because everything is backed up by gold. It's no longer credit no more.
Exactly.
So how these people going to live?
Exactly. That's why I say the system that a lot of people out here knock with the moving away from the gold standard, and a lot of people have issues with it. Like I'm like, I think I see where they're going, but I think y'all view the picture wrong. Think this current system is a better system. Like operating on credit is not bad, and like they say, all debt is not bad debt.
That's what people say who understand that fucking debt is fucking valuable under GAAP principles. But what I'm saying is, I can't believe that I just heard you say that fucking that slavery is a good fucking system, because that's what it is. If you're in fucking slave by virtue of your future labor,
under that gold standard system. There were slaves, and I'm a descendant of it.
But you wouldn't be able to buy a house, though. That's the problem with that. If you go back to just everybody walking around with gold bricks, there's no house loans. Nobody owns a house. Nobody owns a car. Nobody has credit cards. Even your employer works off of credit. So they would have to have less employees because they can't borrow money to make payroll. Like the credit system props up everything.
Well, the fact of the matter is it should be based by something. So it's got to be, if it's not commodity based, it's got to be based off of precious metals or something besides future labor. If it's based off of future labor, everybody's a fucking slave. That's all I'm saying.
You base it off production. That's what currency is based off of, production.
Yeah. Yeah. And it's like your house. It's only where somebody's paying for it.
Who's producing it? Who's producing it? It all comes down to somebody's labor, right?
It comes from labor. Those who are creating it. I mean, you can move to a point to where production is going to be completed by artificial intelligence.
Yeah, depending on what you're talking about.
And so what? Everybody moves in a fucking cage, because that's what it sounds like.
You start shifting where wealth is going. That's what starts happening.
Well, think about photography.
Yeah, go ahead.
But wait, hold on. But think about photography real quick. Quick point. Think about photography. Everybody got a phone now. You used to have to hire somebody to go take pictures at special events. You don't see them people no more. You used to have a DJ at parties. You can whip out your phone and do it. So jobs get eliminated constantly. It's a constant evolve with things.
That's a fact.
I'm not even talking about jobs. We're straying way off the course. Hold on real quick.
No, if you're talking about labor, you got to be talking about jobs.
Yeah, labor is always disappearing.
You're on.
Hey, what's up, Tex?
Hey, what's going on?
How about it?
Hanging in there like a
loose. What's up, M? Damn, M country is you? Where the hell you from, man?
I'm from H-Town.
Oh, you from Houston too? Yeah, y'all country as hell. What's up, man?
Where you at, Em?
I'm just so excited to hear about this court hearing, this court ruling. It's awesome.
Oh, this must be.
I'm still in China, brother.
Oh, right on. So there's a man that's in China. People were asking about China last time, China and Russia and shit. But anyways, so Matt is another American national, much like myself. He's not a citizen of the United States. So anyways, but look, when I'm not talking about jobs, I'm talking about what's considered money. I'm talking about Federal Reserve notes. Federal Reserve notes are backed by future labor. If you want to say that's jobs, great. Okay. But what I'm saying is the debt that's being created and is backed by nothing. All right. The loans are only backed by fucking future labor. All right. Eventually, there's not enough labor. There's not enough fucking slaves that can support the fucking amount of debt. And with that being said, what then? What happens when they call in the fucking the fucking note? Because it's backed by nothing more than our future labor.
Yeah, because what you bring like the call for like the note, ain't those like bonds or whatever?
No, I'm
the loans. You can say the loan securities. It could be anything. But why would they do it though, Tex? Think about it. Why would they do it?
You have a certain date when it's called, right?
No, they can call the debt anytime they want to. Technically, they can call the note the debt anytime they want to, but they're not going to do it because they will have to take the asset back.
It's called acceleration of debt. And if you read the public laws and the Federal Reserve operating circular number 10, $2 quadrillion is all you get to. That is it and no more. They could vote to raise the debt ceiling or whatever. If they can't vote it above $2 quadrillion. And when it reaches $2 quadrillion, they call in the fucking note. That's in the Federal Reserve's own operating circular.
They could change that, man. That's all changeable.
What would make them do that? Could you will crash the economy if you do that?
Yeah, right? Exactly.
People defaulted on shit. Yeah, you wouldn't do that.
No, they wouldn't do nothing like that, bro.
We've been talking about the New World Order and the fucking one world government, right?
I know people wrote about that shit. I don't think it's happening because when you look at shit, there makes no sense for countries to go on war with each other. I don't see that. People are going to fight for the sovereignty. I don't see that. Wait, let me say this. I see people working in unison. I've seen more of that happen than a warm world earlier, because when you're dealing with nations, what nation wants to be secondary to another? Like, nations are always fighting to try to leapfrog the other.
War is used to justify using up natural resources so that other people, that the populace, can't use those resources to develop wealth. They're used up by governments fucking in war. And what are some of those resources? The young men and women that go over there and die or kill other young men and women. Okay, those are fucking resources. Timber, metal, fucking minerals, everything. Paper, fucking all that shit is fucking used by the government to fucking to deplete the resources in order to facilitate perpetual debt that can't be fucking repaid.
But it don't have to be repaid, Tex. Like all the wars we ever go to, it's over oil. That's the strongest resource that everybody tries to get their hands on. It's oil. That's what the whole world needs is oil. Every war that we go to is based off of that. And everything that we do is based off of that. And everybody who buys that, they buy it on credit. So like the whole thing that people are gonna, if any natural resources like gold, it's gonna be oil. And that has nothing to do with us. But anybody who purchased it in the world from any country, they pay in dollars. So I don't think that we're gonna get away from it.
But you understand that fucking that's only been since 1955 that the dollar has been the world's reserve currency, right? And the world's reserve currency prior to that was the Lebanese dinar. All right, and the reason that the U.S. dollar became the world's reserve currency is because oil used to be traded in Lebanese dinar. All right, but the government, the United States government, was politicking, all right, with the Saudi Arabian government in order to become the world's reserve currency. And they said, well, why the fuck would we do that? The Lebanese dinar is more valuable than the US dollar. And so what they did,
but they came after that.
They sent a bunch of CIA agents over to fucking Lebanon and put a bunch of fucking counterfeit money on people's porches so that would get put into the economy and would implode their fucking economy. That happened. And then the next thing that happened is there was a nationalized fucking oil company that was created, Saudi Aramco, okay? That's Saudi American fucking Oil Corporation. Saudi Arabian and an American oil corporation, and they picked up the dollar as the world's reserve currency because the Lebanese dinar had imploded. That's a fact. And fucking, you can look that shit up. Yes.
Saudi Aramco is not. That's not an American company. We don't jointly own them. No, we don't. We don't jointly own them. We don't co-own them. Where's your proof of that? Because they just went public with like 5% of it. And the other problem that you have with the currency thing, they did that after the World War. After the World War, America became the currency on record for the whole entire world. That's when they moved in to the World Bank into Washington, D.C. That's when they came over NATO. That's when all this stuff started happening after the World War. All that other stuff didn't happen. Saudi Aramco was run by the Saudis and not by us.
Saudi Aramco. Saudi Arabian American Oil Corporation. I'm telling you.
Put it on the screen. Type it in. Put it on the screen.
You talking about the name? I'm telling you who owns it. Yeah, you talking about the name? Talking about who owns the reserves?
Yeah, I think that the king up there or whoever he is, the king like that is strictly theirs.
That's theirs. They got
Saudi
like blessed.
Arabian American Oil Company. I'm telling you right now. It is a majority state-owned petroleum and natural gas company that is the national oil company of Saudi Arabia and America. It is the fourth largest company in the world by revenue and is headquartered in Dhahran. Saudi Aramco has both the world's second largest proven crude oil reserves is more than 270 billion barrels. Now what?
Where'd you get that from?
All I did was typed in Saudi Aramco. And that's the first thing that came up. Let's see, where'd you get that? Under Wikipedia, Saudi Aramco.
Okay. Because that's a Saudi company. But either way, they take the dollar. So I don't. I mean,
They do
it's
take the
besides the
dollar.
point.
It says something
Everything
about
is,
it was formerly Arabian American oil.
yeah, it's not. It's all Saudi now because they went public. A part of it, like less than 5%, they took it public like 2 years ago, and they put like $1 trillion
Okay,
on the IPO
just
market.
because they operate in the public does not mean it's a private. It's not a privately owned company.
No, what I'm saying, Tex, if it went, think about it. If they took part of the company public, right? So that means whatever is left, they took this portion of it publicly. America ain't getting no money out of that public money. That's going to Saudi Arabia and that prince or king or whoever that Reggie's talking about. That's who gets
Okay.
that money.
But the United States is a publicly traded corporation with 100 shares, 5%, and it's only got 100 shares. 5% or 5 shares is owned by the Crown Incorporated. I know that.
I don't know about that, bro.
Well, I mean, title. Tell him, Reggie. What did we find the other day? Title 28, USC 3002, subsection 15, subsection A 15. The United States is a corporation. It says it right there in the USC. Then when you look up in UCC 9, in Title 9 of UCC, the location of the debtor, the United States is in Washington, D.C. That's what it says. I mean, I didn't make this shit up. All I did was read it, and now I'm telling y'all about it. And I'm not going to tell you something and then say, hey, you can't, I don't know where to find it, because I've already read the shit. It's right there.
Well, I just don't think that the whole going back to gold stuff, I heard people talk about that, but man, we so far away from that, like Reggie's saying, that it's not even funny. Like, if we went back to gold, we so far away from that, and it's so like uneven imaginable, the things that you have to unwind and what you would do to regular people who barely make. That's what support this whole economy. Like in China, they just build houses and fucking high rises that are empty just to keep their economy going. The credit keeps this economy going. Without that, man, this whole thing would be a mess.
If you go back to constitutional law and you start doing things under the Constitution, you've got to read the Constitution. You've got to understand principles of law. Yes, there's reading involved. There's a good bit of research that's involved in order to understand the difference between public and private, to understand constitutional law or common law. And you place everything under common law contract or common law copyright and common law trademark, all right, within a trust, all right. You do your UCC1 financing statement. You become a secured party creditor backed by your possessions, the things that the debtor, the all capitalized name, fucking owns, and you place the lien against the all capitalized name into the Christian appellation of your name. I gotta answer it. I'll answer it in a little bit. I've done it, and by virtue of UCC1 financing statement, now we're talking about commerce, because everything is in commerce, right? And everything is operating off of debt. Okay, well, we could play their game. All right. Do the UCC1 financing statement, fill it out, fucking send that shit in. And I'm telling you, fucking, I got my UCC1 financing statement right here. If people say that there's no difference between the all capitalized name and the Christian appellation of uppercase, lowercase spelling of the name, if that's a fact, then the Secretary of the State would not have accepted my fucking UCC1 and creating a perfected lien against the all capitalized name that's property of the Drake Allen Gafford private estate and trust under common law copyright. Because by virtue of a perfected lien, the perfected lien takes precedence over any other lien or fucking debt. And in law, the first debt must be settled before the second can be considered. A perfected lien takes precedence over any other fucking debt that has not been perfected. All right. And so if a court is attempted to extort me for $1,000, that's fine. Give me the $200 million first, and you could pull that $1,000 out. Because in law, the first debt must be settled, or the perfected debt must be settled before the second can be considered. Now play with me. I've been studying this shit for a long time, man. I ain't saying nothing that ain't true.
Yeah, but I think the stuff is written, and I think the interpretations go somewhere else with the stuff. Like, I don't think it's like all this stuff is like nothing is hidden. All this stuff is in the codes, regulation, and everything that's out there. I think some people, including yourself, y'all take interpretations to it to think that it's something to work against the people. I think that once you gain an understanding or have the knowledge and understanding, it should better prepare you on how to maneuver through the current way the system is set up, because everything is governed by some type of law, and you just have to find a way to work around that shit. Because there ain't no change in it. There's no going back to a lot of shit that used to exist. Like even bringing up stuff from the Constitution years, like those days go way too far back, and I don't see any of that coming back because the economies aren't the same.
So you don't believe in constitutional rights?
No, I don't think no constitutional rights are taken. I'm black, so the Constitution is something that stands for a freedom after fighting in the damn war. So of course, you want to have constitutional protections, but I think as far as the way the economy works, you want to ensure the economy works to where it's fair for everyone. That's one of the biggest fights. So, but understanding the way the money operates the way it operates. You just want to ensure that it's balanced for everyone. And the problem let me say this: the problem with the economy is that it's in balance based on people's economic status and shit. Your tax.
What I'm saying is you're right. Everything is run based upon credit and debt. Y'all are not incorrect on that. But what I'm saying is if your signature creates the credit, and in the Constitution right here, it states a man's ability to contract and his credit shall be unlimited. That's in the Constitution. If your signature creates the credit and your credit is unlimited, you know, I read those other codes the other day. U.S. Was it? It was Code of Federal Regulations. It was Title 32 of the Code of Federal Regulations. And we understand, maybe we all don't, but we should all understand that a bank is anyone engaged in banking business, right? And I read everything that was right there. Taking the securities and cashing them back in at the discount window, just like T was talking about, turning them back into the discount window for credits of a new issue. And a bank is anyone engaged in banking business. Or you can use the IRS as your personal accountant to the United States Treasury. People got to understand they're simply kings without a fucking kingdom. And their ability to credit is unlimited. To contract and credit is unlimited. And then just start reading. Start reading everything fucking that is financially involved within the Code of Federal Regulations, within the United States Code, within the Uniform Commercial Code. That is your fucking remedy. House Joint Resolution 192, 193. Public Law 78-10. That's your fucking remedy. It's right there. I'm telling people to go read that shit. And when people fucking jump off of here, they sit up on here, man, Tech's pretty smart motherfucker. But they don't go fucking read the goddamn shit. I just told them fucking where the fucking remedy is located.
You gotta understand, you can't force the people because you get on here that they're gonna read it. I think over time, you gotta let people, whoever's gonna warm up to what you read and what you believe in, they're gonna warm up to it. Some people are gonna be opposed to it. and that's the balance of the way shit works.
But why would they be opposed to it? Why would they be opposed to their remedy?
You can't you can't push beliefs on people. You can't do that.
You're right. Okay, and I'm not trying to push a belief. I'm simply saying this is what's written down. This is what the government says is what is. And if people are searching for financial freedom, this is where it's located. Go read it and then act upon it. That's all I'm saying. But if people want to come on and discuss conspiracies and shit like that, okay, that's great. But if people are searching for financial freedom, which seems to be like a regular theme, right? I'm telling them where their remedy is located. I'm just saying.
But when is M gonna speak? But I think what is that? Financial freedom. A lot of people think that. A lot of people view that from the standpoint of working for yourself, becoming your own boss. This is the way a lot of people think of financial freedom.
And yes, this is how you become your own boss as an independent private banker. Because a bank is anyone involved in banking business. And what is banking business? The exchange, the offerings or acceptance of the instrumentalities of commerce. What's an instrumentality of commerce? A dollar bill, a check, a promissory note, an international bill of exchange, etc., etc., etc.
Yeah, because even banks borrow. Banks borrow from banks. Oh, go ahead. Go ahead, Em.
Matt, come on.
Well, I think we're getting a little bit off the point of this whole video. This Supreme Court ruling, like Tech said, this is it. It's the open door to our financial freedom. That's been there for us, but it's been unknown.
And he's exactly right. So
now it's known.
But you didn't really say much, Matt. I mean, you didn't really say much. I mean,
so what I guess, okay, so let's pull it back in, Matt. You're right. We got off topic. The Supreme Court only rules on things that it has never ruled on before. All right. If you take something to the Supreme Court and they've ruled on it before, fucking it's denied because it's already there. And so what they're ruling on is the constitutionality of fiat money derived from a private independent organization that was voted into not existence, but to be utilized by the federal government by a majority of 4 people on Christmas Eve at fucking midnight in 1912. And then it became a thing in 1913. Coincidentally, that's the first time you ever had income tax. It's all right there. It's all right here, right? The Supreme Court, somebody finally worded their documentation in the correct way to where the court would rule on it, the Supreme Court would rule on it, on the constitutionality of fiat money. And they just said, fuck it, it ain't worth a fuck because fucking fiat money is fake. Which, by virtue of this ruling, saying fiat money is fake, people can still use it as a money of money of account, or use it as money of exchange, even though it's not worth anything. If that's what somebody wants to accept, then they can accept it. They can accept fiat money as payment for debt if that's what they want to do, because there is no money. When the UCC has all kinds of provisions from UCC 3, 6, 9, 2. Those titles all cover fucking instrumentalities of commerce, international bills of exchange, promissory notes, money orders, fucking anything is considered commercial paper. That's why I'm saying, if somebody accept a shit ticket that fucking I wrote this worth $100 on, then fucking goddamn it's worth $100. I think that we should start a fucking movement. No pun intended. That any shit tickets offered by fucking Tex at $100 a pop are worth $100 a pop. If enough people accept it, it becomes fucking accepted. Just like a dollar bill. It's pretty smooth paper. We start wiping our ass on that while I start fucking passing out $100 fucking Charmin. It'd be backed by the same fucking thing. Nothing. So by virtue of this decision, all loans are null and void. As long as you express your rights. Because those that do not express their rights have none. That's a maximum law. So anybody who's got a loan should bring this to somebody's attention. Hey, I can't pay you back because there's no fucking money of substance. Supreme Court ruling in Moore v. Alliant Credit Union. There is no money of substance.
But what about like Matt? So Matt lives outside the United States. I'm pretty sure things operate the same way in China. Or am I wrong, Matt?
Oh, there's nothing like what we're talking about right now.
Matt is a starving artist, and so but he's a very good artist. As a matter of fact, I think everybody should commission something from him. So I was telling him, I said, hey, the yen is backed by gold, and he said, well, in China they don't allow anybody to own gold. Okay, but the Chinese yen is nationalized, right? And it's backed by fucking gold. There's no centralized bank. Just like Russia. Russia kicked the centralized bank out, fucking back to ruble by gold.
Gold would stagnate a country like China. There's too many people in it, and their economy is booming. Like they would never live by gold standard. They'll adopt this fiat system of loans and credit and taking companies public and doing all the other shit they're doing.
The Chinese yen is backed by gold. That's why they're considering it for the world's reserve currency.
Yeah, but if people there don't retain gold, then it can't be the standard. People are still living off of the system that we have. Pretty sure they have to go to work. They go to work, they earn wages, they have accounts they can save, and they can also probably pull loans. As their economy kind of mimics what they have gained from us as they start to open that country.
The government is in possession of the gold. So the Chinese yen is nationally, which sucks because
America, but that's the same thing with America. The government owns the gold here.
The government ain't got no fucking gold. You and I both know there ain't a fucking goddamn ounce of fucking gold dust in the goddamn fucking Fort Knox, Kentucky. You know it and I know it. We were both there.
Well, unless they sold that shit to another nation, it could be stored somewhere else.
Yes, that's why in 1933 they had to fucking pay off the debt because the United States went fucking bankrupt. They gave the fucking gold away after fucking raising the price on it so that they could fucking pay off the debt. The United States went bankrupt in 1933. The United States is in a fucking constant state of it's always been bankrupt since then. It's always in a state of reorganization. That's why the United States is the fucking parent corporation, but there's always another DBA that's created, whether it's the U.S. or the U.S. or fucking currently the White House Incorporated, the White House Offices Incorporated, We see the motherfucking corporate logo every time somebody comes up there to give a press briefing. We see it. The fucking United States seal ain't up there no more. It's the seal of the fucking White House Offices, Inc. By the way, anybody operating under a foreign seal, the White House Offices, Inc. is registered in Canada, all right, is foreign to America. Look, the fraud is so fucking expansive and goes all the way up to the top, from the top to the bottom and back again. And globally, the fraud is all fucking there. It's fucking ridiculous. If you look up fucking where the state seals are registered, where the United States seals are registered, where every agency of the United States has their own seal, where that seal is registered, it's registered in Canada, registered in Canada, registered in Canada. Why? Because Canada is owned by the Crown Incorporated, is owned by fucking Great Britain. That's why when you go to Canada to go hunting, you've got to pay the Queen's tax, because those are her animals.
Again, guys, these are such deep waters.
Preach.
I mean, I'm almost with Reggie compared to Tex as far as like understanding all this stuff. I mean, it's been years that I'm studying and researching, and it's still, there's so many parts, it's hard to understand. But going back to what happened a few days ago in the Supreme Court, the most important part of this whole deal is you get a loan, you get a mortgage, you buy a car, and you default on that, right? What's going to happen? Court is going to try to repossess or take you to, a bank is going to try to repossess or take you to court, right? Not the mortgage company, not the car dealership. They have already gone through the bank and been paid by the bank, who has gone to the Federal Reserve window, right? So now with this court case, we have the ammunition to win in court against these banks.
Exactly. You do have the
See if you can explain that a little bit, Tex.
Okay, so that is the ammunition to win against the banks, because all contracts, it just said it, the contract is null and void if it's deemed, look up that definition, that legal definition, to be repaid in Federal Reserve notes or United States dollars or whatever they're considering consideration, because they have no value. So if you don't pay it back, it doesn't matter, because paying it back with Federal Reserve notes is the same as paying it back with nothing. And if you pay it back with nothing, or you simply have nothing to pay it back with, it's the same fucking thing.
Yeah, because even in this situation with the foreclosure on the guy's house over a defaulting on the loan, I think hopefully I'll see that the Supreme Court is going in this direction, that you don't make things easy just because you default on a payment. You miss a payment, and the bank is able to, based on how they write a contract, to where you defaulted, now we throw your home into foreclosure. We repossess the loan after all you didn't invest in that shit, and you lose everything. I definitely think there should be protections against the banks making shit so easy for them to retain a property in order to put that shit right back on the market, sell it to another person who runs into the same risk of them repossessing it. I think it should, the initial holder of that property should be worked with. There should be protections to help get them back on track, even if they just miss the payment or two payments. Like, I think the protection should be there in scenarios like that.
So there are.
I think this court case is that,
and this, you know, this is the protection against it that doesn't keep stained within a slavery type dichotomy between yourself or ourselves and the bank. Okay, let me read this one time. So first, I'm gonna tell you the legal definition of the word consideration. All right, the legal definition of the word consideration is simply money. All right. This clause right here, clause 2 in section 6 under the conclusion says, we further declare that contracts based on fiat currency lack valid consideration and cannot form the basis for lawful enforcement actions. Banks may not foreclose anymore. If they loaned out fiat currency or credits, I mean, they're going saying that your signature is the credit. Further up, when they're talking about signing the promissory note, they're going out there and saying without saying it, if you read between the lines, that the signature was the credit. They cannot loan their own credit, for they have none. What they're saying is, by virtue of signing that promissory note, the bank, you utilize your credit as one of the people, as a living man or woman. You use your own credit to purchase whatever, the automobile, the house, the land, whatever you purchased, okay? Under contract, saying it's got to be paid back with Federal Reserve notes, all right? That's fiat currency. And fiat currency, any contracts based on fiat currency lack valid consideration, lack valid money. On you. Not anymore. People got to know this shit, because people that don't express this shit don't fucking know it. You have a motherfucking lawyer out there that's that's going to represent. This is what I talk about. There is not everybody, by virtue of the Constitution, the Fifth Amendment and the Sixth Amendment of the Constitution concerning due process of law. Everybody has the right to competent legal counsel. You will not find a motherfucking bar attorney that's competent legal counsel, because fucking they're all in cahoots with each other. Their first duty is to the fucking bar association. The second is to the court. The third is to whoever their client is. So people got to know this shit and then go in and fucking present themselves. You cannot represent yourself. You can present yourself to the court under special appearance, thereby challenging jurisdiction. You could present yourself, sue juris in propria persona, just so Lee.
This is the thing, Reggie. There will continue to be fraud in this country.
The fraud is so expansive,
but only because of ignorance.
Oh yeah, oh absolutely. Because I always speak on that about the ignorance of people in society.
And I've been that ignorant. So
if the world could watch this show. Yeah, we all have.
Exactly. If the world could watch this show, you know, I don't talk about anything that isn't based upon something that's already been written down. Everything I talk about, you know, I mean, yeah, we go off into conspiracies and stuff, but when I'm giving you facts, fucking, when I'm telling you the truth, fucking, I'm telling you where to find the shit. It's all been written down, and it says what it says, and it don't say what it don't say. Now, under presumptions, assumptions, and color of law, you don't want to presume anything, and you don't want to assume anything, because that's what they're fucking doing. So they're interpreting it to be whatever they want it to be. They're interpreting that you're incompetent because you're assuming that all the verbiage in there is going to be under the common definition, but it's not. It's all under legal definitions. And if you know the legal definition, I preach this all the time. Learn your fucking legal definitions, because when you read the shit, fucking goddamn, it will terrify you after you learn the fucking legal definitions. I tell everybody, look up the legal definition of person, because in all these contracts, you as a person, this, and this. Look up the legal definition of person. What's a resident? What is res? What is res? A res is a fucking thing, and is generally deemed to be enslaved. And a residence is fucking where a thing fucking is the geographical area that a thing occupies. And everything we fucking sign is a legal document. Why are we fucking assuming that the common fucking definition of it applies? It doesn't. Everything we fucking sign is a legal document. Everything that's presented to us is a legal document. If we start learning the fucking legal definitions, we're going to be fucking terrified. And then we're going to get fucking mad. And when we get fucking mad, shit fucking starts to happen. I've been mad for a long fucking time.
And being mad ain't a good state to be in neither. I think the thing is finding
I agree. But when I got mad, I didn't just go out and start like fucking torching the place, fucking whatever. I got mad and I wanted to fucking learn. So I started reading the fucking legal definitions.
And so how did you readapt to finding what you have found in the system you live in? How do you go about with what you learn? Because when you learn something, you do better. And therefore you don't make the mistakes. You know how to guide your path through things in society. So with the current way things are, how have you readapted and strategized? Because a lot of the changes you talk about, they're not going to happen like that overnight.
Right.
So at some point, and even with what you gain, you still have to participate in how things are and just be able to outsmart them and not be taken advantage to where you're a victim of, if you're not knowledgeable, how you get duped in the system. So how have you gone about that?
So the first thing I did is I started to utilize my my knowledge as armor. All right. Because I was being pulled into fucking court and shit. All right. So my knowledge was my armor at that point in time. I have just recently reached the point to use my knowledge as a weapon. That's why I sued the fucking mortgage lender for trespass to try title and quiet title. You know what they did? They called me on the 16th. They was already well out of their fucking window to respond within 20 days of receipt. Ongoing case. I mean, I probably should be talking about it, but fuck it. Right? Fucking the legal representative contacted me on the 16th. And he said, "Oh, I just got this. Can we have another 30 days?" I said, "No." I said, "I'll stay in honor. I will stay in honor, and I will grant you 14 days. Okay, well, I'll write this up, and then it'll get sent to the court, and then when the court sends it to you, and then when you sign it, and then you send it back to them, then we'll start I said, "Nope." I said, "You've got 13 days after today." I said, "As a matter of fact, you don't need to fucking write up nothing. I'm going to go drop this off at the courthouse and file it into evidence. I'll write up something that grants you the 14 days. If people, like I said the other day, if people understood the fucking power that they have, this shit wouldn't go no further than fucking than anywhere. When people
that's the
understand,
thing. If we only
go ahead, Matt.
If we only play defense, you can never win. We have to be on offense.
I understand, but that takes an immense amount of understanding.
We have to take them to court. And
yes, it takes an immense amount of
I'm not trying to say anything to you. I know you know what I'm talking about. I'm just speaking to the viewers and Reggie. It's an offensive game, and this court case is the golden bullet.
It could be, but
No, I'm glad to see the courts give, because this is an individual, right? To give this individual the victory in this case. I'm happy to see that, because I think a lot of things, that's why I refuse to even buy a house in the market. I don't like the way a lot of things are done within the housing market. I think it puts homeowners at unfair advantages, especially with the extreme pricing of property that ain't even worth the value that they place on that shit. And you go through any little hiccup, one default, and the banks have for centuries been allowed to confiscate these properties that people have invested in. And I think so I like what this case, the outcome of that case.
So right here, I have my complaint that was sent to the Mortgage Corporation. First of all, I state within the complaint that who's named on the complaint, that the plaintiff, being me, I'm over the age of 21 years, and that is important. Over 26 is really important. Reaching the age of majority, it's important to have that in there, have a firsthand knowledge of the facts herein. Because a bank is not going to send a representative of the bank to the court case, to any court case. They have not done it. The last time they did it was in 1938. And the attorney that was against the bank for whatever the issue was made the motherfucker cry on the stand, and he had to admit that fucking the currency is backed by fucking nothing, and that the signature is what I'm not going to go any further into that case because I don't remember the name of it, but I will find the name of it and I will go over the whole thing in a future podcast. Anyhow, I stated that the Mortgage Corporation is organized under the laws of the United States with multiple offices, that I own in fee simple and possess, that the property is located in where it's located and described as follows in Exhibit A under the meets and bounds. That I have exclusive, complete, actual, open, notorious, hostile, continuous, and undisputed possession of the property for more than 10 years. That I have a release of lien that's recorded at the county. The defendant is claiming an interest in the property adverse to me, and that the defendant's claim is without any right, that they have no estate, right, title, lien, or interest in or to the property or any part of it, that there's no landlord-tenant relationship. You got to put that shit in there. Because if they claim that there's a landlord-tenant relationship, that creates a fucking creditor-debtor relationship. And if it's not stated right off the bat that there's no landlord-tenant fucking relationship, and you got to understand history with this shit. Landlords and tenants were fucking masters and slaves. Historical context means a lot when it comes to the fucking law. That plaintiffs and plaintiffs' predecessors in interest have paid all the taxes assessed or levied against the property during the adverse possession. Defendant and all persons claiming under defendant be required to set forth the nature of their claims to the property described in paragraph 3. The defendant and all persons claiming under defendant be required to set forth answers to all interrogatories requested by plaintiff that they have thus far been unwilling to answer. I've sent them fucking a list of 81 interrogatories. You know how many of them they answered? None. They said, "Oh, these are legal theories that we just don't prescribe to." Oh, really? It was a computer generated fucking response. These are legal theories you don't fucking you don't prescribe to. I sent you every motherfucking thing that said this is the fucking law. I printed it all out and sent it to them. How can they fucking say it's a legal theory that they don't prescribe to? It's not a fucking theory. It's all fucking written down. It says what it says and it don't say what it fucking don't say. I sent them the affidavit of Walker Tucker. Now tell me something. Oh, no? Okay. I sent all the fucking consumer laws. I sent them everything from fucking Code of Federal Regulations to United States Code to UCC. All of the fucking case law. It's a legal theory we don't prescribe to. Okay. The defendant and all persons claiming under defendant to produce an original deed of trust and original promissory note that thus far they have been unwilling or unable to produce by my request. Why? Because as soon as they fucking got that shit, if they ever fucking got that shit, because they have no fucking claim on this fucking property. There is no fucking deed of trust. I've been paying on this shit for fucking damn near 10 fucking years and it's been fucking paid for. I've got the fucking release of lien. They can't produce no fucking deed of trust because if one ever exists, or promissory note, because if one ever fucking existed, they bundled it in a bundle and fucking sold that shit on the open market. And it's held some fucking where that they do not fucking know where it's held. Or it's held by the fucking holder. It's held by the fucking investor that bought the goddamn security. Plaintiff does respectfully move and pray for relief by court order to trespass to try title and quiet title concerning property. This is shit that fucking I wrote. I didn't have a fucking attorney do this on my behalf. Everybody can fucking do it. Everybody is capable. It just, you got to fucking read. And I know it's hard to fucking start because you don't even know where to look. Once you understand the fucking fraud is so expansive, it pisses you off. Where do you start? At the fucking beginning. Page 1, Black's Law Dictionary, 8th edition. Start there. I'm pretty passionate about this fucking shit because nothing is more important.
So I assume.
Go ahead, Matt.
I assume you're going to be using this latest Supreme Court in your case.
Yes, I absolutely am. I'll be printing it off and fucking getting it over to the courthouse within a week, placing it into evidence.
Yeah, it's beautiful, you know. So there's been previous court cases, you know. You stated some, and I'm sure, you know, Reggie, he had them in all his paperwork. But some of them go back to the 1800s. Now we have one from 2025, right in their face.
Exactly. So, and that's the deal. When I talk about historical content, is very important. You know, when the court says we operate under statutes, but what is a statute exactly? It's short for statute merchant. The statute merchant law was created in the 1300s. And I've talked before about the fucking about the English language. That the word asking is a conjunctive verb, as king. Because from the king, all right, is where all the waters of knowledge flow. That's what it was. And so it still is, right? And so the waters of law flows from the king, right? The king's word is law. Statute merchant was created in the 1300s. And if they're operating under statutes, they're operating in commerce. That's a fact. Look at anybody's jacket. It's going to say detrimental or something similar to that to interstate commerce. In the United States Code, when it's talking about federal crimes, I don't have the code right in front of me, but it states that that crimes like extortion, keeping houses of ill fame, et cetera, use of marijuana shall be considered commercial crimes. How does a contract between two fucking people become a commercial crime? Somehow or another, if they can tie in fucking interference with it, with interstate commerce, that's how it becomes a commercial crime. There was another recent court case, exactly, through fraud and through the ignorance of people. Fucking, you want to know the fucking enemy of us? We need to start looking in the fucking mirror, because it's all there. And if I'm telling everybody it's all there. If people choose not to fucking look, they're their own fucking enemy. So
that's how we got ourselves where we are now.
Exactly. It was through fucking through laziness, through fucking indoctrination of the educational system, and not just the indoctrination, but the willful lack of education. Right? Civics gave you a broad overview of this shit. They don't have civics in fucking school no more. Lawyers, when they go to law school,
they've had all the lawyers on their side for a long time.
Exactly. When lawyers go to law school, they don't learn one motherfucking law. Not one. They learn how to write briefs. They learn fucking rules of procedure, et cetera, et cetera. But they don't learn one motherfucking law. They go over a little bit of case law. And whatever case law they go over, I would bet a dime to a motherfucking donut, it's commercial case law that's beneficial to the fucking state, not to the fucking people.
Same thing that's happening in the medical industry. The doctors have been indoctrinated. And these lawyers, if they're not complicit, they're indoctrinated. And
it's hard to point the finger of malfeasance.
Have just been swept under.
Exactly. Lawyers either don't talk about this shit because they don't know it, or they fucking want to argue with you over the validity of what I'm fucking saying, because they've been indoctrinated to believe one thing and one thing fucking only. And they think they're fucking smarter than everybody else. But they could argue with me, because I'm going to tell them where the fuck to find their fucking laws at. Just like when I used to have Facebook, Reggie. You remember when them fucking flatfoots pulled me over? And what did I ask them? I said, hey, I've heard that ignorance of the law is no excuse for breaking it. And they said, yeah, that's right. And I said, is it a prerequisite for enforcing it? Because they didn't know what the fuck they were doing.
You still got that video?
I damn sure do.
You should upload it on here.
I will the next podcast.
No, you don't gotta do it in the podcast. You can add it as one of your videos. Just upload it and title it.
Oh, okay. I'll do it then. I'll do it right after this.
All right, and then because I'm about to get ready. I'm gonna do mines in about an hour, so I'm gonna get ready to make my kids some food real quick.
All right. Well, we'll jump off of here. Then just man.
No. Don't stop. Don't stop because of me. Remember, this the other thing with YouTube. Keep doing this shit. Whatever information, whatever thoughts you got, keep doing this shit. And then, like I said, it's so easy to do it now because you started your like how you set up the live. You can do this shit anytime a thought pop in your mind. Run that shit. That's how I always do it. I may be out, like I say, I'll do live streams. Just I'm out and something pop in my head, or I may read an article and I'll be like, I want to talk about that shit. Set up a live, or I got to show you the other thing on how to create a video. Say you can't go live, you got an engagement later, but you want to speak on that. You can create a video, and I got to show you how to do that shit too.
Yeah, we'll go over that shit in the future. But hell, take care of them kiddos, and I'll keep cooking for a little bit.
All right, now I'll be tuning in. I got it on my phone. I'm listening through my earpiece.
All right, bet.
All right, Matt.
All right, have a good one. Adios.
Reg.
So there was a court case, a Supreme Court case just recently, and they were trying to hit him with a felony because he was carrying. He had a loaded pistol in his car, and he was pulled over in a school zone. And so they said, "Oh, well, he was carrying a firearm." First of all, look up the definition of firearm. A firearm in a non-firearm zone, or whatever they call it. And the judge asked the fucking prosecuting attorney, how does carrying a firearm in a school zone affect interstate commerce? That motherfucker had balls. The prosecutor couldn't answer the question. Fucking everything was tied to interstate commerce. It was in his fucking jacket. And they dismissed the fucking case. All the way to the Supreme Court for that fucking shit. Why? Because fucking the legislature may create any inferior court. So Congress and the Senate may create any inferior courts. And if they're inferior, if they are, just real quick, Matt, if they are an inferior court, they don't have jurisdiction to hear criminal cases. Right within the Constitution, it states that a felony case must be predicated by a grand jury indictment. Any criminal fucking case, any criminal case. I go in there for a goddamn speeding ticket and I say, okay, what's the cause and nature of the action? Well, we've already read it into the court 3 times. Okay, could you please read the cause into it? Okay, and then, well, what's the nature of the action? Well, I've already read it. I said, okay, oh, maybe I'm not asking the right questions, Judge. Are the nature of these actions civil or criminal in nature? For the record. Oh, well, it's criminal. Okay. Let the record reflect that the court has stated that these are criminal actions. Now, Article 3 of the Constitution, to my understanding, allows for 2 criminal jurisdictions. One being that in common law, and the other being being that based upon contractual agreement and obligation of a highly colorable maritime admiralty jurisdiction. Which one is it? Well, they don't want to answer. Get a fucking answer. All right? Maritime admiralty is fucking commerce. Except none of these legislative courts are fucking competent to rule in common law. They can't rule in fucking common law. It's always maritime admiralty. And they're going to bullshit you. And they're going, well, this is a statutory jurisdiction. That's statute merchant. That's commercial. That's a court of fucking equity. All right? You say statutory jurisdiction. Okay. Well, I've been unable to find within the Constitution a statutory jurisdiction. Can you please provide me with the rules of procedure of statutory jurisdiction? Well, I can't give you legal advice. Maybe you should hire an attorney. Well, I'll take that under advisement, Judge. But I'm not looking for legal advice. I'm looking for your legal intent. Well, this is a statutory jurisdiction. For the court is operating under a jurisdiction that is only known to lawyers. Let me put that shit on the record. I'll put on my fucking clown suit any goddamn day of the week, these motherfuckers. To navigate commerce, y'all. Anyways, go ahead, Matt. I'm sorry. I went off on a fucking tirade.
I was just going to say, we can only hope that an increasingly larger amount of judges will start, representing this whole thing correctly. I think there are starting to be some, as the suits get to them, they're scared to keep pulling all this fraud.
Well, Supreme Court justices, but there was I believe it was Antonin Scalia, and I may be wrong on that when I'm giving this quote, but it was stated by a Supreme Court justice, and I think it was Antonin Scalia. This is probably why he was murdered, but made the statement that 98% of all judges and lawyers are corrupt, incompetent, or both. Why are they incompetent? Because they didn't learn a motherfucking law in law school. They think that the fucking statutory law is fucking common law, and it ain't. Once they're apprised of that shit, they start rethinking their fucking oaths that they gave to the bar association and fucking their second obligation to the court. But it doesn't keep them from doing what they're doing. Because why? Because they're corrupt too. And they want that money.
Oh,
but
yeah.
I'm glad to see
offshore accounts and retirement.
There are actual patriots. That's right. The 801k, the judge's slush fund, all that shit from them unauthorized bonds. That's right where it goes. An offshore account known as the fucking 801k that's only available to fucking judges, the judge's retirement account. And I've never seen, Matt, I've done a lot of shit since the last time I talked to you. And I've been utilizing my Fidelity account to look up these fucking municipal bonds under standard forms 24, 25, and 25A. And I've never seen one for any less than fucking $4 million. Never. Is that unjust enrichment? I'd say so, yeah. Is that a conflict of interest? Judge, what's your interest in this case? They don't want to answer. Imagine that.
Yeah. Yeah, these are some deep waters. People need to learn.
Yeah, and some of these motherfuckers don't know what's going on. My bad, Matt. I'm talking over you. Go ahead.
Oh, man. I'm here to listen to you. I'm just making little comments. I mean, these are deep waters that people need to understand that, to start with, they're going to have to represent themselves. And they're going to have to learn this stuff. But once they do, there shouldn't be another foreclosure. There shouldn't be another, anyway, all this stuff, we can win it.
Yeah, like I said on the last podcast, and I wish you'd been there for that. People got to understand who they are. They need to know who they are and the power that they have. Every single podcast, I say the people are only governed by consent. The power is in the people. The government was created.
Yeah. Of course, we got to get out of all these contracts. We got to get out of all these contracts.
I mean, a contract is fine if you want to fucking create a contract and you want to contract with someone because your ability to contract is unlimited. Therefore, it must be inferred that your ability to not contract is unlimited, and that your ability to rescind the contract is also unlimited. That's the inference there. And so,
yeah,
people need to understand that everything from the government is contractual. You either consent or you don't. You either agree to contract or you don't agree to contract. Or you're forced to contract, which is void upon its face. And then you've got these fucking sneaky unilateral contracts, which they call them unilateral contracts. The Constitution calls them bills of attainder. And no entity may pass a bill of attainder. Because what is a bill of attainder? It's one entity saying, hey, you violated something that I made up, so you owe me money. Or you can sit in a cell. Bills of attainder were big under Edward III. That's where the bill of attainder fucking came from. Historical inference is fucking is you've got to understand the history of law. And then you've got to understand principles of law. And you've got to understand definitions. And you've got to understand the difference between public and private. And you've got to understand separation of powers. It ain't fucking easy. They've made it fucking easy for us by hiding it in fucking bureaucracy. Oh, we don't have to learn this. We could just hire an attorney. Shit. And we didn't know that the attorney's first obligation is to the Bar Association. That every court matter will be considered private bar guild matter. Their second obligation is to the court. How is the court bringing their cases? By virtue of the state entities, corporate entities. And so the court is operating on behalf of the state. And so you've got a prosecuting attorney, you've got a fucking attorney that you hired or that you were appointed, and you've got a fucking judge all working for the fucking state. Because all of their obligation is to the court. And if their obligation is to the court, then their obligation is to the state. And the state is the one bringing the charges. Where's the conflict of interest? Oh, it's all over the fucking place. That's where it is. It's just void upon its face. But if you throw out the fucking attorney, the representative attorney, all of a sudden you've thrown a fucking wrench in their plans. And you don't go in there and you don't represent yourself pro se. Pro se means that you have a complete and full understanding of the fucking law and its implications, and you are held to the same standard as somebody who has been formally trained or educated in law. That's what pro se is. You go in propria persona or pro per. And when I've told these fucking courthouse clerks, oh, so you're coming in pro se? No, I'm coming in pro per. I've never heard of that. You think that was constructed by design? Yeah. You think that was conveniently fucking left out? Yeah. Otherwise, they'd be asking you, are you coming in pro se or pro per? I've never heard of that. What does that mean? And I said, it's embarrassing that I've got to fucking teach you this, but it's not your fault. As king, you ask the questions.
Wow.
You're the sovereign. We the fucking sovereigns. They the fucking servants. When was the last time you ever heard of a servant fucking asking questions to their fucking masters? When was the last time you ever heard of a free man fucking answering the question of servants? You haven't. Me neither.
Absolutely.
I'm the free man here. I'll ask the questions. Y'all provide the answers, and they better be correct, because I've done my homework. I've done my homework, so if you're going to fucking perpetrate fraud upon the court, I'm going to know it as soon as you open your fucking mouth. But anyways, we've got true patriots that are Supreme Court justices. It hadn't always been so. But the courts of common law have been embattled with the fucking courts of maritime admiralty forever. The courts of common law ruled in the United States of America until 1938. Pacific Railroad v. Fuck, I can't remember that one either. Anyways, a guy was struck in the head by a board that was protruding from a rail car, and he claimed injury. Under common law, he sustained an injury. Under maritime admiralty, it was his fault for being there. Now, the fact is the Pacific Railroad fucked up. And Pacific Railroad fucked up. Because the railroad is the largest landholder in the United States of America. They own 20 feet on either side of the rails, outside the railroad ties, on both sides. Or maybe it's 40 feet. I don't know. It's a lot. But the railroad is the largest landholder in the United States of America. Under common law, he would have been trespassing onto private property. But that's not the way fucking the railroad worded their shit. They worded it commercially. He shouldn't have been there. So fucking, when he was struck by it, that was his fault. Instead of saying he was trespassed. And so fucking common law was thrown out the window. Commercial law fucking come right on in. And that's when there was a blending of equity and maritime admiralty. Going straight back to statute merchant. Anyways, the power is in the people. You can always call for a competent court of common law. If you're calling for a competent court of common law, understand difference between public and private. Understand common law. Understand what it says in the Constitution and have that motherfucker with you. And when you start bringing up codes and regulations and all that shit, fucking the first thing that's going to happen is the prosecutor's going to stand up and say, oh, now you're mixing stuff up a little bit. No, I'm not. I understand the difference between public and private, but you're public. As you're a private corporation operating within the public, and you are fucking contracted thereof to represent them in the public arena. So all the public shit is what you're bound by. It doesn't apply to me. The common law does. Now, if you're not competent to prosecute a case under common law, then what are we even doing here? Since common law is the true law of the land, not statute, merchant, maritime admiralty. Common law is the law of the land. Call for it. Write a call for judicial review under common law. There's templates all over the fucking internet. Quit using the goddamn device that you carry around your pocket that has all the information from the beginning of time till now. Quit using that motherfucker to argue with strangers and fucking look at pictures of cats. Start using it to educate yourself, because self-education is better than any public education you've ever received. Of that, I can assure you. Matt, you got anything else?
No, brother. I'm just glad you're on my side.
Always, bro. Speaking of which, hey, have you heard from Landry lately?
No. Well, I mean, a couple of days ago.
I tried to call him a couple of days ago, said that he wasn't accepting my calls, so I don't know what the hell's going on there.
No,
Maybe he got a new.
No, he's hadn't paid his bill.
Oh, fair enough. Well, maybe he ought to send him that fucking document that has a picture of a badge on it. Anyway,
he's getting it together.
Good. Hope so. Anyhow, all right. Well, I'm gonna get off of here. I think this is a pretty good tirade.
Well,
I'll tell you.
The truth
I'll
with
tell you
text.
the
truth with text.
That's right. That's right. I'm gonna tell you the truth in a world full of lies now. All right, Matt. I'm gonna get off of here. It was good to hear from you again. Hear your voice. Hold it down. You said you was gonna be back pretty soon. When you coming back?
Might be back in February.
Right on. All right. All right, Reggie. All right, Matt. Well, I'm gonna turn this thing off. I'm gonna rustle up some grub and feed these dogs and whatnot. All right, hippie. Yeah.
All right. I look forward to the next one.
Yes, sir. 10-4. I'll let you know when it goes down.
Just the beginning.
Y'all have a good.
Yeah. Okay. God bless.
All right. Adios. Thank you.